Hey everybody, it's Wednesday. Welcome to True Crime Wednesday. I'm Lori Hellis. I'm a retired criminal attorney and have written a book about the Vallow Daybell case, which it hits the shelves on September 24th. Welcome. And of course, that muted my microphone. So welcome to you all, and glad you're all here. While we let the chat catch up, I wanted to talk about a couple of things. I know that tonight is the Democratic National Convention, and I know that there may be people out there who are catching that rather than tonight's show. And I wholeheartedly support that, no matter which party you support or which candidate you support. I wholeheartedly support all of us being informed voters and educating ourselves and voting. So I will see you all on the replay, all of you folks who have decided to tune in to the convention instead. And thanks for doing that. It's important, and it models those good choices for our kids and for our neighbors. So please be informed and engaged voters. I have a little something, a request for all of you that is very close to my heart. When I first moved to Idaho, I met 4 women who reached out to me to get to know me personally and to offer to show me around and tell me where all the good places were in Boise. And one of them in particular, she's hilarious. She said, I'd never written a fan letter before, but I wrote a fan letter. And she reached out to me and I said, great, let's do lunch. We had lunch and really connected and got to be really great friends. She and her sisters are the ones I went to McCall, Idaho with to go kayaking a couple of weeks before we moved. And she's just really become a part of my heart. She is married to a retired physician, and he is in the end stages of Parkinson's. They have hospice at home, and she is saying goodbye to the love of her life. So please, 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 no matter what your faith is, no matter what your belief system is, please send out good feelings for Jane and Bruce, for peaceful transition for him, and for strength and a sense of love surrounding her. I am grateful that she has a large family and they're all surrounding her and holding her up. But she has been a faithful listener of our podcast since it started. And so she's one of us, one of you. And I'm just asking that you please just send up good thoughts and prayers for Jane and Bruce. Thank you for that. We have a lot on the true crime agenda tonight. I have a whole bunch of little sticky notes that have next court dates coming up. So the next thing coming up for us is next week, the 26th through the 28th. Corey Richens is finally getting a preliminary hearing. So I'm going to be following that. This week, I have been following the Robert Hellis case. He pronounces it Tejas, I think. And that's a really interesting case. That's out of Las Vegas, Nevada. He was the public administrator. He is accused of murdering an investigative reporter who published several very unflattering articles about him and about the administration of his office. He was an elected official. He then lost in the primary and wasn't reelected. And the investigative reporter was stabbed to death outside his home. So his trial is going on right now. It's been really interesting to watch. And as I started, I came on because they're in Las Vegas, they're an hour off from where I am on Pacific time. And he was on the stand. So it's quite unusual to have a defendant take the stand, but there he was. And so I'll get back to that and be able to report back next week about that trial. But it's been very interesting. And I have to say, the prosecution has done a very good job. They're very organized. They've done a very good job of keeping things moving, of only going after really the information that they need from witnesses. They've been very efficient, and it will be very interesting to see because Mr. Hellis's contention is that he was set up to look like he had murdered this reporter because he was rooting out corruption in the public administrator's office. I think that's a little bit of a reach, but we'll see whether the jury buys it or not. We got some really encouraging news. A lot of you have asked about the Dee Warner case. This is a case out of Michigan, and Dee Warner went missing in April of 2021. Her husband, Dale Warner, was at least her second husband, and they hadn't been married very long. But her husband, Dale Warner, was arrested. Her family went to court and asked the court to declare her legally dead, which the court did. I think earlier this year. It may have been late last year. And they have always believed that Dale Warner was responsible for her death. There was clear indication that there was domestic violence, that it was not a happy marriage, and that he was very controlling, and she just disappeared. So actually 2022, the family petitioned to declare her dead. I don't believe it happened in 2022 though. And they did that because they wanted to bring a wrongful death suit against Dale Warner. And they couldn't do that as long as she was simply presumed to be missing. But this week, there was a huge development because Dee Warner's body was finally found, and it was found buried in a like a tank, almost like what would be on the back of a tanker truck, and it was a tank that held fertilizer, and it was. Her body was inside. The tank had been welded shut and then painted over so that it didn't appear that it had been tampered with. The family, the same day as the remains were found, confirmed that it was Dee, and the law enforcement later confirmed that as well. So that is really good news because it is always very difficult to prosecute a murder without a body. It's not impossible, but it is much more difficult. So, of course, we're still waiting to hear from the court on the Karen Reed case. Her retrial is scheduled for the 27th of January of 2025. And the judge had a hearing on the defense's motion to dismiss the case on the 9th of August. The judge took it under advisement, and we still have not heard a ruling from her. I do not believe that the judge is going to dismiss the charges based on the fact that the jury unanimously found her not guilty on those 2 charges. I don't believe that there is legal precedent for her to do that. And I think that over the objection of the state, I just don't see that she'll do that. So I think that the retrial will go forward in January unless the district attorney decides to do the right thing and dismiss at least those 2 counts. I think that the reason why they hung on the 3rd charge was because of the verdict form. And it's really interesting because there is a little piece of video where you can hear the judge saying this didn't get changed, suggesting perhaps that the changes that she made to the verdict form didn't get made. And when the verdict form came back to her, she realized it was incorrect. So that's concerning, but I think that her defense attorneys need to be very, very clear about what they want the verdict form to say. What was interesting was there is in Massachusetts a standard verdict form, and they didn't use it. And comparing the 2, if you look at the 2, the standard verdict form is much more explanatory, much more accessible, makes much more sense. So I think it was a huge mistake on the defense's part not to push back and insist that they use the standard verdict form rather than the verdict form that was created by the prosecutor. So that one's going to be interesting to see. I kind of hope we might get a decision from Judge Cannoni next week, but we'll have to wait to see. There's still repercussions going on the Ashley Benefield case as well. Her sentencing is set for October 22nd, but her attorneys filed a motion for a judgment of acquittal post-trial, and a motion to interview jurors because they allege juror misconduct. They say that before the verdict, a guy on Twitter, I believe, that goes by the handle That Hoodie Guy, he's a YouTuber as well, posted information. Oh, here's what happened. I got to read my notes first. The guy, That Hoodie Guy, posted comments in the Law and Crime on the Law and Crime feed saying, quote, verdict incoming, then posted a comment outlining what the jury votes, the numbers were, and the outcome, how many jurors voted in each way. He said, my sister snuck in a flip phone, and he says they may have to compromise on manslaughter. So the question is, did a juror, presumably That Hoodie Guy's sister, sneak a flip phone in, and was the jury communicating with people outside of the jury room during their deliberations? So was there a juror that compromised the deliberations? There also was a juror who lied about being involved in domestic violence and having experience in the criminal and legal system. So they are asking for a judgment of acquittal, or at a minimum asking to interview the jurors to find out whether or not the deliberations were compromised. So it will be interesting to see whether or not the judge interviews the jurors. I think that certainly is appropriate to question the jurors about whether or not their deliberations or the privacy of their deliberations was compromised. I don't think that they get an acquittal. What they're saying is that the jury found her guilty without proper evidence, and that there wasn't evidence to support the jury's finding. That's a common motion that gets made. However, I don't think that one goes anywhere. Now, Sarah Boone. Sarah. So Sarah Boone keeps demanding a bit of special treatment. She's asking, now I want to point out that I think that there are some of the things she's asking for are reasonable accommodations because she's having to represent herself. But she is asking for things that are special treatment within the jail. So at the last hearing, she asked for a whole laundry list of things. She asked for she asked for access to the internet, access to a telephone that she didn't have to collect calls on her Telmate system. She asked for paper copies of all of her documents so that she could write and make notes on them. That doesn't seem that unreasonable. There's a large volume of discovery, and it's difficult without being able to use a computer to be able to categorize and file and figure out discovery, and then to make notes about it and have the notes go along with the discovery. So it makes a certain amount of sense that she wants to be able to make notes directly on the discovery materials. She originally was given the paper copies of her discovery in 2 cardboard banker's boxes. And the jail said that there is a limit on how much paper any inmate can have with them because of the fire hazard. And she was given a fireproof bag to put any of her paper goods in. So one of the compromises was that the jail would give her another 1 or 2 of these fireproof bags. They also would give her manila envelopes without any latches or metal in them, so that she could file and keep things separately filed. So this person's interview would be in that envelope, and so that she would be able to find things and be able to file and categorize her discovery. She also has access to a laptop, and all of the discovery is on thumb drives. That's important because many of the things are videos and photographs. So she's able to view the videos and the photographs on the laptop, and she's able to actually view the paper discovery either on the laptop off the thumb drive or in the hard paper copies. And those I thought were reasonable accommodations for her. They were not going to give her access to the internet, and they were not going to give her access to unlimited access to a telephone. So here's the dilemma. And I do understand why she's asking and what she's asking for. The entire court systems have all gone electronic. So everything is filed electronically. If you file a motion with the court, you file it electronically, and all of the service on all of the other parties, all of the service that we used to do by mail or by fax is all done electronically. But she does not have access to the internet and to that electronic system. So when let's say the prosecution files a motion, she gets a paper copy mailed to her. So it has to go through US mail. That means it has to go through US mail, however long it takes for it to go through the post office, be delivered to the jail, and then it has to be processed by jail staff before it is given to her, and that can take days. So as she complained at the last hearing, she didn't know that there was going to be a hearing that day because the motion had been filed the previous day. The court set that motion the same day, and she went down to court not knowing what the motion was about. She isn't clearly at a disadvantage. However, it is a disadvantage of her making. It's a disadvantage of her making for alienating at least 6 lawyers, and it's a disadvantage because she is in custody. So she does have an investigator. She has someone who is being paid to act as her private investigator, to interview people, to review discovery, to go out and find things. And she has every right to have her investigator making phone calls to line up witnesses and making sure that he is receiving the posts that are he's receiving the motions and anything that's being posted to the website. Sorry, I just got a text that distracted me for a moment. So she asked for access to a word processing application like Microsoft Word, and the jail said, absolutely not. We can't download things onto the laptop that she is using. So I think it's a fine line because some of the things that she's asking for are reasonable, but some of them are not. The other thing she asked for was to be able to use a classroom where she could have a private workspace. Now, here's what's going on. She is in a dorm, an open bay dorm. Think military basic training, beds lined up side by side, locker, and that's where she is located. She has access to a day room, but she is among other people in this pod, in this dorm, all the time. So they sleep side by side and they're in the day room all the time. And I mean, she has people around all the time. So she was saying it was difficult for her to listen to some of the things that she's, the interviews, the videos, those sorts of things, because of all the noise and distraction, and they're not private. So she was asking to be able to do that in a classroom. She was also asking to be able to have headphones of some kind so that she could listen privately to things that were being played on the laptop. And the jail said no to both of those, that they wouldn't commit their classroom because it's used for other purposes, although she points out it's not used all that often. They did not believe that giving her headphones would be, could be a safety issue because she wouldn't be able to hear when she was being given directions, etc. So they offered that they could move her into her own cell in a different portion of the jail. She promptly said, but that's maximum security. And the jail supervisor said, no, the designation of that area has changed. It is not necessarily maximum security. And if you were to move there, then you would be able to do all of this in your cell. And she didn't want to do that because she felt like it would restrict her freedom of movement and her ability to be around all the other people in the jail. So she declined that. As I say, she does have a private investigator, and he is available to do a lot of work for her. The court has authorized up to $10,000 in fees to him for her to direct him to do things. So I think the judge basically said to her, you are going to have to rely on your investigator. So I saw a question early in the chat asking what sort of role she would have in jury selection. And it's a great question, so I do want to address it. She will be able to ask questions. There it is. Hi, Bo Peep. She will be able to ask questions, and just as if she were an attorney going through voir dire. So she could ask for a change in venue. I don't know if that would be of any particular benefit to her. I think her case was kind of notorious, although she has been in jail a long time. This crime happened several years ago now. And I think those delays have really served to kind of let it fade from people's memories. So, it's possible that somebody could say, oh yeah, I remember hearing about that woman who zipped her boyfriend into a suitcase, but I don't really remember much about it. I didn't pay that much attention to it, or I don't really remember any of the details. I just remember seeing it on the news a long time ago. And I think you'll probably get a lot of those kind of answers. So, but she absolutely will participate in voir dire, and that could be really, really interesting. Voir dire tends to be a little boring, but with Sarah Boone doing her own, it could be, you could maybe want to get the popcorn ready. The next step on the docket is our South Carolina Murdaugh case. Alec Murdaugh, the disgraced South Carolina lawyer from the South Carolina Good Old Boys Network. The Supreme Court, this is a little interesting because in general, when you file an appeal, you must appeal to the intermediate appellate level court. And then if you don't agree with their decision, you can appeal to the Supreme Court of the state. In this case, the Supreme Court granted Murdaugh's attorneys the right to skip over the appellate court and have their appeal go directly to the South Carolina Supreme Court. What they're complaining about is Judge Toll's ruling that even though there were some questionable things that happened with Miss Becky, who was the court administrator, it did not raise to the level of juror misconduct. And Miss Becky has since resigned from her elected position, and she is under investigation both by SLED, the South Carolina Law Enforcement Division, which is their state police, and the State Ethics Board. So she still has a lot of liability hanging over her head. And so in the meantime, Alec Murdaugh's attorneys have alleged that Judge Toll made the wrong decision in ruling that there was no influence over the jury by her statements. And so they have been given 30 days to file their opening brief in that case. So in an appellate level action, the first thing that happens is the moving party, which is usually the defense, files their notice of their intent to appeal, and then they have a certain amount of time to file their opening brief. That is their brief about why they believe that the court made mistakes in their rulings. So that opening brief happens, then the state will have the ability to answer that, and there likely will be in-person argument before the South Carolina Supreme Court by both sides, and then the court will make a decision. I wouldn't anticipate that's going to happen anytime soon. Oftentimes people, both sides will ask for additional time to get their briefs in. Often it takes months to get to the point where there's even a hearing date set, an argument date set before the Supreme Court. So we could be a year or two down the road before any decision is finally made about Alec and whether or not the jury was influenced in their decision on his case. That only applies to the murder case. The other cases, all of the financial fraud cases, both state and federal, are not involved in this, and so those sentences stand. So I don't know that even if the court were to grant Alec Murdaugh a new trial, there would be a lot of opportunity. There would be much chance that he'd be getting out of jail. There wouldn't be any chance that he'd be getting out of jail, out of prison. So, and the next case I want to talk about is out of Florida, and that is the Loren's case. This is the woman who fired a gun through a door and shot a woman on her front porch who had come over to confront her because Ms. Lorenz was harassing the neighborhood children over playing in a vacant lot. The jury found her guilty, and the question was whether or not the death of the woman was justified or excusable. And when the jury decided that, they did not decide whether Ms. Lorenz, whether her actions for herself were excusable or reasonable. They had to apply a standard of what a reasonable person would have thought was excusable or justified. And they found, and I believe rightly so, that her actions were not justified. She shot a gun through a door. She didn't really know who was on the other side of the door. The woman was there, but also her young son was there, and not only experienced watching his mother be shot to death, but could have been injured himself. That certainly does not meet the reasonable person standard. So she will be sentenced, and the maximum sentence is 30 years. She's older, and likely a 30-year sentence would be a life sentence. But the court could impose less than that 30 days, or that 30 years, sorry. And then we have a little bit of stuff going on with Shanna Gardner. And Shanna Gardner is the woman with the murder for hire case with Jared Bridegan, having her former spouse, her ex-husband, killed. This case is interesting because Jose Baez, who represented Casey Anthony, is her attorney. And he is, as anybody who knows, he is a very assertive, aggressive defense attorney. And he is very methodical, and he he has gone after the prosecution for, once again, not fully turning over discovery. He says they hid text messages, including a text message among friends, with another woman that she knew, discussing a hitman. Now, they had that woman into court, and she said that was a long-standing joke she had with another friend, and that really it didn't have anything to do with Shanna Gardner, other than that Shanna sort of got in on the joke later when she became friends with her. They also claim that the lead detective lied and the prosecution withheld information. So Jose Baez is looking for a dismissal and also a bond reduction. So at this point, I do not believe the court has decided those things. It was a little hard to find the court's decision. I don't believe it's happened yet. But the court wasn't real sympathetic to the issue that the prosecutor was not turning over discovery. And that just seems to be a very common complaint. Now, do defense attorneys make that complaint frequently? And do defense attorneys sort of, as a rule of thumb, make that complaint? Absolutely, we do. But it does seem that there are a number of cases where the prosecution at best has been sloppy and at worst has been hiding the ball. And so we've seen a number of those cases. We saw it in Alec Baldwin's case. We saw those complaints in the Reed case. We saw them. We saw Alec Baldwin get dismissed. We saw many of those complaints in Vallow Daybell. We saw the death penalty taken off the table because for Lori Vallow because of discovery violations. So it happens, and it is the defense attorney's job to make sure that, to the best of their ability, they're ferreting out information that the prosecution may not have provided. Now, the prosecution has a legal obligation to provide all discovery. Now, the law says it is discovery that can be used for impeachment, discovery that suggests other avenues of investigation, or discovery that's exculpatory or might lead to exculpatory information. That's a pretty broad net. And I think prosecutors, it is frustrating when a prosecutor will say, well, Judge, we don't believe this is relevant information, so we didn't think we needed to turn it over because we're not going to use it. That's not the standard. And the prosecution in Vallow Daybell tried that. Well, we don't intend to use it, so we didn't think we needed to turn it over. That's BS. And that is absolutely wrong. Because and think what you might about John Pryor. Pryor said this repeatedly. It is not up to the prosecution to decide that. I get to decide what's relevant and what's not. It's not the prosecution's job, or they don't have that power. It is not up to them to decide that. I don't care whether they decide for their case it's not helpful to them and they're not going to use it. But that doesn't mean it's not relevant to a defense case. And it doesn't mean that it isn't information that could plausibly lead to other investigative avenues or could lead to exculpatory information. And the prosecution doesn't know that until they turn it over to the defense, and the defense begins digging into it and doing their investigation. So we have seen an awful lot of this. This is not the first time we have seen prosecutors who are walking a very fine line of violating Brady rules and discovery. The Supreme Court case is Maryland versus Brady versus Maryland, sorry. And it led to all states codifying the prosecution's obligation, so making it part of their statutes, the prosecution's obligation to turn over all material. So moving on, Crystal Rogers. That's one we haven't talked about in a while. Crystal Rogers disappeared and her body has never been found. So we are yet again with another no body murder. Her boyfriend, I think, her significant other, I don't believe they were married, Brooks Houck, has been arrested along with two other people, Stephen Lawson and his son, who were accused of her murder. At least one of the Lawsons has admitted to moving her car to where it was found. So Stephen Lawson worked for Brooks Houck, who was a fairly well-to-do property owner and employed quite a few people. And it was really interesting because in the middle of a hearing, a pretrial hearing, Stephen Lawson stood up and said, "I need to fire my lawyer." And what happened after that was a kind of a little bit of courtroom drama. He said he didn't believe that his attorney was working for him. He believed that he was working for Brooks Houck. And what was really interesting was the prosecutor stood up and she said they had some real questions about whether or not the attorney, Stephen Lawson's attorney, had a conflict, whether Stephen Lawson had conflict-free counsel was the way she phrased it. And she reported that Lawson's attorney had been meeting with Houck's attorney behind Lawson's back, and that many of the motions that this attorney had filed were literally carbon copies, right down to the same errors and the same typos as in Houck's case. So Lawson's lawyer was apparently cutting and pasting Houck's motions. She also said that Lawson had an immunity, in the immunity motion. There were a lot of similar errors in the immunity motion. So she was very concerned about whether Lawson really understood the immunity motion and the court's order. The court granted his motion to replace his attorney and said, appointed the public defender and asked them to come back on the 22nd of August to have the new attorney appear. Now, the judge did not change the upcoming trial date, and I don't have that in my notes, but it wouldn't be surprising if Lawson's attorney, public defender, came back and said, "I need additional time." It seems to me that trial is scheduled for October. So lots of folks have asked about Lindsey Shiver. She is the woman who is being prosecuted in the Bahamas in a murder for hire scheme. Now, fortunately, these folks were caught before anyone was hurt, but they are all on trial in the Bahamas. I was of the understanding that she had been allowed to go to the U.S. on an ankle monitor over the holidays, over the Thanksgiving, Christmas holidays, but that she was back in the Bahamas. That's not the case. She is still in the U.S. on release, and her trial was originally scheduled for, let me look it up. It originally was scheduled to begin shortly and has been moved to October. Actually, I think her trial originally was scheduled in March. It may have been that she was back in the Bahamas for that court hearing, and that court was set out till October. The Bahamas, they don't necessarily publish dates the way that U.S. courts do. So, Kathy White says new trial February 2025. Okay, I hadn't heard that, but thank you. So we'll keep looking into that. It's still really interesting. I'm telling you what, Fox Hill Prison is not anywhere anybody would want to be. So I think she spent some time in Fox Hill before she was bonded out and out on release. And I think that she probably does not want to go back to Fox Hill. For anybody who doesn't know, Fox Hill regularly makes the list of the top 10 worst prisons in the world. And that includes Colombia and Mexico and a lot of places that have notorious prisons. So it's not anywhere you'd want to be. Turning now to Delphi, and it's no surprise that Judge Gull has once again denied their motion to dismiss the case. She also denied their motion to permit third-party actor evidence. She said it was unsupported by law and the evidence. One of the things that they were complaining of was the fact that the key witness, the person who the defense believes committed the murder, was interviewed by the police, and that police interview was recorded over inadvertently, apparently. The judge found that there wasn't any evidence of bad faith, that it wasn't intentionally destroyed, that it was negligent, and they have the report. And so in an absence of bad faith, they can't get that information thrown out. She did order the prosecution to turn over discovery that the defense has been asking for, and that it is once again pretty outrageous that this far into this case and this close to trial, the prosecution still has evidence they admitted they had not turned over to the defense. Very outrageous. The 23rd of August is the next hearing. Now, unfortunately, Judge Gull, it cracks me up, Scott Reich gets the greatest amount of amusement by the fact that her name is Frances C. Gull, like seagull. Anyway, Judge Gull has continued to deny all of the motions for recusal, and she has banned cameras in the courtroom. So the only information that we get about hearings, or that we will get from trial, are from people who will be in the courtroom. Now, I know that Bob and Allie Mata, Bob plans, he is in Illinois and he has been attending the hearings. His YouTube channel is Defense Diaries, and he has been attending those hearings and will attend the trial. So I expect that that Bob will be there on Friday to let us know what else is going on in the Delphi case. But Judge Gull has absolutely not done any favors to the defense from the beginning, from throwing them off the case and having to have the Supreme Court order them back on the case, to continuing to deny all of their motions, to refusing to approve their fees for their investigators and their experts. they had to do a GoFundMe campaign in order to hire experts, which is really outrageous. So I don't know that Judge Gull is going to fare very well in the appellate court if Richard Allen gets convicted. But as I've said before, and a lot of other lawyers say, post-conviction work and getting a conviction overturned is like claiming Mount Everest. The very best thing that it can happen is to keep people out of prison to begin with, to get them, to have them found not guilty, rather than having to try and challenge a conviction. So that is going to continue to be an issue. I don't think Judge Gull is going to fare well with the appeals court if he's convicted, but I think it's really unfortunate that it has to go there rather than getting a fair trial to begin with. The next thing I want to talk about is Adelson. Donna Adelson's lawyers filed motions in her case to dismiss her case because of the 9-year delay in indicting her. This is something I think you all might want to chat about, so I'll be looking to see your comments. As in most states, in Florida, there is no statute of limitations on murder. However, on one hand, you want the prosecution to have the time that they need to put together a solid case. On the other hand, letting a case go for 9 years, you run the risk of information going stale or no longer being available. Witnesses die, their memories fade, or in this case, phone records get overwritten or destroyed. And so they say, the defense says, that they are at a disadvantage because exculpatory evidence wasn't preserved because of the lengthy delay, and it having to do with her, with the destruction of her phone records. So most companies have a time limit, a period of time where they automatically purge documents and recordings. There's automatic destruction. And so they argue that even within the statute of limitations, delay can be prejudicial. So they claim that that it was bad faith on the part of the prosecution by waiting so long. Now, the prosecution is going to say, this is how long it took us to put the case together, and it was the prosecution's prosecutorial discretion, which is very wide, to go after these people in this very methodical, knock down the pins sort of way. And now we end up with Donna Adelson, and it took us 9 years to get there. I frankly don't think that this is going to get them a dismissal. What they're saying is that they wanted to be able to prove that the phone patterns, the texts and the phone messages and the phone calls that we saw after the bump, if you remember about the bump, were not atypical patterns around other events having to do with Donna and Charlie. They can't do that because her phone records were purged. Now, so I'm kind of curious what y'all think about statutes of limitations. There are a lot of people who don't like statutes of limitations, meaning in general, in misdemeanor cases, the statute of limitations is somewhere around 2 or 3 years. And in felony cases, other than murder, it's somewhere between 5 and 10 years. Depends on the state, depends on how they classify the crimes. But there is an end date. So there are instances where people are not prosecuted within the statute of limitations. Now, the other thing to remember, though, is that statutes of limitations don't always, the time doesn't always count. So, for example, in the Adelson case, where they fled the country, even if there had been a finite statute of limitations on their crimes, the time that they have fled the country and are on or have absconded often doesn't count toward the statute of limitations. There are also instances where when a person is already in prison, the statute of limitations doesn't toll. So it really depends upon the state law, and it also depends on some extenuating circumstances. For example, if a person is trying to get a restraining order against in an abuse, domestic violence situation, most of the rules having to do with family violence restraining orders say that the abuse has to have happened within a finite period. Some states it's 6 months, some states it's 180 days. But that time doesn't toll if the abuser is in jail. So it is interesting that the law does allow for statutes of limitations and similar limiting statutes to toll under certain circumstances. And one of those circumstances often is when a person absconds and leaves the country. So it's possible that even had there been a statute of limitations, Donna Adelson, had she left the country, would not have been able to avoid prosecution. She would have been able to avoid prosecution because Vietnam didn't have an extradition treaty. It doesn't mean that she couldn't have been brought back to the US, but it would have taken a lot more than is typical. And the other thing would be that that the statute could toll while she was out of the country. So the last one I wanted to talk about is the Hellis or Tejas case out of Nevada, Las Vegas. And we talked a little bit about it at the very beginning because I was watching the trial as I started the live. The prosecution rested, and yesterday the defense began calling witnesses. The defense called a psychologist. For those of you who may not be fully up to speed on this case, the defendant, Robert Hellis, was a public administrator. He was an elected official in the Clark County government. And his job was to administer estates that were where the person died without a will, died intestate. He went to law school and then opened his own probate practiced for a couple of years, and then ran for a position as an elected official. He'd formerly, before he went to law school, been involved in real estate and in property management. So this office is a place where they administer, meaning they take care of the estates of people who die without a will. And that includes selling their real estate. So when real property is in limbo because the person doesn't have a will and there isn't a statutory beneficiary, then this office takes over and administers liquidating the estate and dividing the money among the surviving family beneficiaries. So it often means selling real estate. There was some indication that realtors were buying this property up at low rates, that they were friendly with the public administrator's office, that they were buying up this property at low rates, cheaply, doing a little fix up and turning them and selling them for large profits, and that was going on all the time. And that there was a certain level of corruption within that public administrator's office. So Mr. Hellis comes into office, and there are a variety of stories about what was happening in that office. Some people say he was harassing people, that he was bullying people, that he was calling people out. Other people say that the staff were routinely racking up additional overtime, 30, 40, 50 hours a week of additional overtime. Some people were doubling their salaries with all the overtime that they racked up, and that he put a stop to all the overtime. And so the people in the office were disgruntled. In amidst all of this, it's clear that he had a romantic relationship with one of his employees. That caused a lot of contention as well. And some of the employees went to an investigative reporter named, whose last name was Gehrman, spelled like German, but pronounced Gehrman. So Mr. Gehrman, who was an investigative reporter for the newspaper, started looking into their complaints and their contentions. He actually went to the public administrator's office, interviewed Mr. Hellis and a couple of his staff members, and wrote his first article about what was going on in the office. He followed it up with 3 more articles, each one of them a little bit more contentious, a little bit more accusatory. And Mr. Hellis was running for re-election. Another person in his office challenged him in the primaries, and he lost his primary. And so this other person ended up taking office as the public administrator. When Mr. Gehrman was killed, he was pulling into his garage, similar to Danny Markel. He pulled into his garage, and then he walked out of his garage and walked up the side of his house to enter his house through a side door. The cameras in the area, ring cameras and surveillance cameras in the area, caught this individual wearing dark baggy pants, an oversized bright orange like sun shirt that a lot of people who work outdoors in Nevada wear, and a broad brimmed straw hat. So his face was not visible. He was wearing very distinctive Nike tennis shoes, and he was seen walking up the side of Mr. Gehrman's home some time before Mr. Gehrman arrived. Then you see sort of movement behind bushes. You can't really quite tell what's going on. And then this same person in the orange shirt walks out and walks back down the sidewalk. He is later seen getting into a car a couple of blocks away. It appears to be the car that belongs to Mr. Hellis's wife. So when they start looking at all of these articles and sort of trying to put things together. They also do an autopsy. And during the autopsy, they take fingernail clippings and scrapings, and unknown DNA turns up under Mr. Gurman's fingernails. And as they continue in the investigation, they find out that that DNA profile identifies Mr. Hellis. So they have a direct DNA link. So his contention, the defendant's contention, is he's being set up because of all these people in the office who hate him, because he's the one who hit him in the pocketbook by cutting back all their overtime and started pointing out all the corruption that was going on in the office, all the friendliness with all the realtors and all of those things, and that he was set up. However, there's a lot of evidence that points to him being the culprit, including the very distinctive Nike shoes, one of them being cut up and both of them being found underneath his recliner, along with the cut up straw hat being found in his home. So there's a lot of evidence that would indicate that he is the culprit. His defense has been trying to poke holes in the state's evidence, but there really is no way to poke holes in the connection with the DNA. So when the police go to serve the warrant and arrest Mr. Hellis, he's alone in his home. His wife and children are gone. And they discover, or they try to take him into custody, and there happens something of a standoff, and it goes on for a couple of hours. They then send in their robot and a drone, and they're able to fly the drone up the stairs and through the house so that they can see what's going on. And they discover that Mr. Hellis is in the bathtub, and it appears that he has self-inflicted wounds. So they then enter the house, come in with the paramedics, and they treat him for these self-inflicted wounds, and he goes to the hospital and then to jail. The police are look through the house, collect evidence throughout the house, and find this implicating evidence. So the defense is trying really hard to poke holes in this. So they bring in this woman who has reported to the police that she saw this guy, a strange guy, dressed just like the guy that law enforcement put out the video on, in the dark pants and the orange shirt and the big straw hat, and he's wearing a COVID mask, a black COVID mask. And she sees him in a nearby park, and he's going in and out of the men's room, and he's kind of lurking around, and she thinks it's creepy, and she's worried that kids around the park aren't safe, and so she reports it to police. The defense called him, which is really odd. Clearly, they weren't really sure what he was going to say, she was going to say, because when the state begins to question her, she says the guy walked out and he started running at one point, maybe because she was paying too much attention to him. I don't know. But he starts running. And when he runs, the hoodie he has on comes off, and he is a white, bald guy. So now we have the possibility, because Mr. Hellis, if you haven't seen him, is just bald as a cue ball. In fact, Bob Motta's been calling him Boss Baby. He's got a very wide forehead and this big egg head on top. And so he's pretty distinctive. And she says he was a light-skinned, bald guy. Now, this was not on the day of the murder. This was several days before the murder occurred. So, who knows? Was it him? Was he doing a dry run? I mean, it's impossible to tell. But I don't think the defense has done themselves any favors. They put on a psychologist to talk about the fact that if a person attempts to unalive themselves, it is not necessarily consciousness of guilt. I think that's a reach, but the defense was trying to say, well, it could have been many other things. He could have been depressed. He could have been, the psychologist came on to say it's not necessarily true that someone trying to unalive themselves could be viewed as consciousness of guilt. But I certainly think the prosecution is going to argue that, and they are entitled to argue consciousness of guilt and to get those jury instructions. So I could see that happening. The last witness that they called before Mr. Hellis got on the stand was someone who confirmed that someone either using the app on his phone or a key fob checked in at a nearby Planet Fitness at 12:09. Now, Mr. Gurman's time of death is somewhere around 11 or right after. And so it is entirely possible that he could have left the scene and gone to Planet Fitness, maybe to clean up. So I think the prosecution's put on a pretty straightforward, very efficient case. I'm not sure that the defense has done themselves any favors. And Mr. Hellis is on the stand. I don't think he finishes today and probably will be on tomorrow. He has been permitted to sort of give a narrative. So he's just sitting up there like word vomiting. And I think that is incredibly dangerous. A defense attorney should never let their client just get on the stand and give a narrative. It's so dangerous that they're going to say or do the wrong thing. But he's up there just blah, blah, blahing and wanting to show evidence of this terrible conspiracy in the office and how he was being set up. So I haven't watched the last of it yet, so I don't know how that is going to come out. But I think that anytime you put your client on the stand, it's dangerous. And as a defense attorney, I would never allow a client to just get up there and word vomit. Doesn't make any sense. So I think that I'm to the end of my recaps, and I would love to hear what you all have to say this week. So let's take some questions. And Mary, hi, Mary. Nice to see you. Do you think Boone will take a plea deal? I don't think so. The prosecution asked the court to set aside time when they could sit down with Sarah Boone, present their evidence, and discuss a plea with her. This is something that has been done with her court-appointed lawyers, with all of the lawyers she's had. Now, the last lawyer, Pamela Cashman is her name, told the court that she had spent 20 hours with Sarah going over everything. So it is not as if Sarah Boone doesn't know the evidence against her and doesn't know the theory of the prosecution's case. She does. She just believes they're wrong. She just believes that the jury will believe her when she says, oh, it was all an accident. We were drunk and playing a game, and it was all just a terrible accident. She completely discounts that video that she took herself and was on her phone of her taunting him while he's inside the suitcase, telling her he can't breathe. I don't know how she gets around that, but she absolutely just la la la. I don't want to hear it. So I don't believe that she will take a plea. I think that the prosecution will once again try and get her to take a plea, because there is a certain point at which you feel like it's shooting fish in a barrel. I mean, the prosecution's got to feel at this point like she's pro se, she's representing herself, and they really don't want to be seen as the power of the government steamrolling over this poor unrepresented woman. So I think they will do everything they can to try and present her with their side of the case and present her with things to consider, a plea to consider, but I don't think she'll take it. I think that is part of her pathology. Ladybug Lady, do you think there's any way Boone could be found innocent? No, I don't. I mean, like most defense attorneys, I like to give people the benefit of the doubt, and I like to see all the evidence before I express my opinion. But I've seen that video, and in fact, if you have not seen it, trigger warning, it is hard to watch. There is a link in our show notes to that video. It is video she took on her phone of him inside the suitcase. You can see the suitcase moving around and you can hear his voice of him saying, "I can't breathe. Please let me out. Sarah, please, please. Babe, I can't breathe." And her drunkenly slurring and saying, "You deserve it. This is what happens. This is what I feel like when you don't pay attention to me. This is what I feel like when you, and I mean, it's very difficult to watch. But knowing that video is going to be exhibit number one, I think it would be very difficult for a jury to find her not guilty. Good question, Ladybug Lady. You got to be busy. It's summertime. It's got to be ladybug season. For those of you who don't know, Ladybug Lady breeds and grows ladybugs to be sold to nurseries and to gardeners as a pesticide-free way of getting rid of aphids, especially on roses. Jacqueline Dotson, I wonder why Gull's superiors don't intervene. She is so obviously thwarting justice. It's really hard to watch, but here's what I'll say. In most jurisdictions, South Carolina is an exception. In most jurisdictions, judges are elected, and there's only a certain point at which any state actor can call out a judge without demanding a recall, because they are elected officials. So there's only so much that the superior judges can do. Now, my understanding is she is a senior judge. She is the presiding judge in her jurisdiction. That's an appointment that just happened fairly recently. The job of presiding judge is purely administrative. It's scheduling and administrative work and making sure the courthouse runs smoothly and the bench runs smoothly. It is not really a supervisory role where you supervise other judges, because you're not their boss. The people are their boss, the people who elected them. So the next place that they could go is the Supreme Court. And the Delphi defense lawyers have gone to the Supreme Court. The problem is that they have to have the basis to file an original action. to get to the Supreme Court prior to trial. And they have tried that on a couple of occasions and have not been able to get the Supreme Court to take up the issue of her bias. So they're kind of stuck at this point. And the trial's going to go forward. It's scheduled in October, and it's going to go forward. And I have no doubt that she is going to hogtie them when it comes to their defense. She is going to put limitations on the evidence that they can bring in left, right, and center, because she has already telegraphed that. So, and I think, unfortunately, the only relief for Richard Allen is going to be at the appellate level, because I think their attorneys are going to be limited on what they can bring in as far as a third-party culprit goes. So, I mean, I find the evidence against Richard Allen incredibly thin. The evidence is an old bullet that they found underneath the girls. The girls bullets weren't used in the murder, and that old bullet could have come from anywhere. And the science having to do with bullets being worked through the workings of a gun and left unfired is just junk science. So I'm hoping that they're going to be able to go after that junk science and say, without that bullet, you don't have any link of, you don't have anything that links Richard Allen to these girls. And there is linkage other places. Now, whether or not Judge Gull is going to let them bring in the linkage in other places or not remains to be seen. I think that it has been a real miscarriage of justice all the way along. I don't know whether Richard Allen had anything to do with the death of Abby and Libby, but I don't know that he did either. I don't know that he didn't either, I guess I should say. I don't know whether he is responsible, but the prosecution doesn't know that either, because law enforcement doesn't know it. And they are going on very thin circumstantial evidence. And it's troubling to see our system work in that way, because we rely on our system to give due process to everyone, so that if we end up in our legal system, we're assured that we're going to get due process, and that if we are innocent, we are going to have our rights protected. And it's very troubling to see that that's not happening in Delphi. So it's very unfortunate. I'm getting a little raspy, guys. So if they charge Wendy Adelson, will she try and say that as well? Probably, very probably. I saw something going on Kohberger, but I didn't see if there had been any kind of a ruling or anything that that was a new development. So y'all may know more than I do. So Nikki, if you want to be specific, let me know. Because I did see in my feed as I was going through trying to listen to Hellis that it appeared that there was something up on Kohberger, but I didn't see it. And I usually go right to Andrea Burkhart for that information. She is a lawyer out of Eastern Washington State. Washington and Idaho border one another. And in fact, Brian Kohberger was going to college in Pullman, Washington, right across the border from Moscow, Idaho, when he was pursuing a PhD in Washington. So I usually go right to Andrea because she usually has the documents and the straight scoop, but I didn't see anything. So Nikki, if you have something to post, please do. And I definitely will follow up on it. I just didn't have the opportunity today. So any other questions? Jacqueline, How can us East Coasters get an autographed copy of your book? Well, I am hoping that there will be some book signings, but I also will be working with my publisher to work on an order mechanism so that folks can get their books autographed. So that is one of the questions that I have on my to-do list to talk to our publisher about this week. Our publicist at the publisher's been doing a lot of work, working on a lot of different publicity avenues. We're starting to work on some book signings. And so I hope that there will be an opportunity for folks who are not in the Pacific Northwest to either send your book to me so that I can autograph it, or there'll be a mechanism for you to order one that's pre-autographed. So I will bring that up with my publisher. Thank you for asking. This whole book publishing thing is kind of new territory for me. So, Bo Peep, was there a grand jury for Sarah Boone? What's the difference between a pretrial and a preliminary? Oh, good questions. Okay. I believe there was a grand jury for Sarah Boone. So what we know is that constitutionally there has to be an investigation into whether or not there is probable cause to believe a crime occurred and that this person is the person who committed the crime. Probable cause is a pretty low standard. It's 50%. It's just saying, I think there's a 50-50 chance this guy is the guy who committed this crime, or this person is the person who committed this crime. So there are two avenues to do that, and states have an option. They can either convene a grand jury. Grand jury is a group of citizens who get together, who review the evidence and determine whether or not there's probable cause to believe that crime was committed by that person. The other alternative is to have a preliminary hearing and have a judge decide whether or not the evidence that's been presented is probable cause to bind that person over for a trial. So those two avenues. So some states prefer one, some states prefer the other. In Idaho, they usually prefer preliminary hearings. So when Lori Vallow's case came up, when Chad Daybell's case came up, the initial case where they were charged with the destruction of evidence and of destroying or moving evidence after the children's remains were found, but had not yet been charged with murder. They were charged with these felony evidence charges as a way to hold them while they continued the investigation. The state opted for a preliminary hearing. And so Chad Daybell had a 2-day preliminary hearing, 2 or 3 days. And during that hearing, the judge at that point was the magistrate, Judge Edens, found that there was sufficient evidence to bind Chad over for trial. Lori Vallow had been scheduled for a preliminary hearing the following week. Following that preliminary hearing, she waived her right to a preliminary hearing or a grand jury. And so she waived and submitted to the indictment. When the murder charges were being investigated, the prosecution decided that there was enough out in the public. They did not want anything more out in the public. And so they opted for a grand jury instead of a preliminary hearing. The holdup for them was it was right during COVID. When they had the preliminary hearing, they did it with COVID precautions. Everybody there were a limited number of people in the room. The witness box had plexiglass around it. Everybody was wearing masks. And but when they decided they wanted to convene the grand jury, so because grand jury proceedings are secret and private, They didn't want any more evidence getting out to the public. They couldn't convene a grand jury because grand jury proceedings were on hold because of COVID. So if you remember in the Vallow case, it took them a very long time to finally get to a grand jury and an indictment for the murder. It was almost a year, actually, after the children's bodies were recovered. And a lot of that had to do with the fact that they couldn't get a grand jury all together to review the evidence and find probable cause. So that's a preliminary hearing. That's what's coming up for Corey Richens. That preliminary hearing will be the prosecution laying out sufficient evidence to prove to a judge that there's enough evidence to bind her over for trial. Pre-trial conferences happen very frequently, and they are really much more a scheduling function. So pre-trials are held to ask everybody, do you have motions you need to file? Do we need to schedule hearing time for motions? If so, here's your deadline for motions. Here's the discovery deadlines. Here's the date that we're going to have the trial. So they're really much more administrative kinds of hearings. So a pretrial, like you, is coming up on I talked about too many cases tonight. The pretrial that's coming up on Dee Warner's case, that is, oh no, I'm sorry. The next hearing that's coming up on Dee Warner's case is a preliminary hearing. So that will be where the judge will review the evidence to find out whether or not there's probable cause. However, in the Crystal Rogers case, where the judge allowed his attorney to withdraw and set another date for August 22nd, tomorrow, that judge, that is a pretrial. And that pretrial is to find out whether the new lawyer is up to speed, whether or not the new lawyer needs extra time, whether the new lawyer has had an opportunity to review the discovery far enough to know whether there are going to be preliminary motions, all of those things. So preliminary hearings are really to review evidence and find probable cause. Pretrial conferences are administrative and scheduling. So good questions, because, you know, as lawyers, we throw these terms around all the time, and they all sound alike. And so I can understand how people who aren't in and out of court all day might say, well, what's the difference between a preliminary hearing and a pretrial hearing? They sound alike. And you're right, they do. But they have very different functions. So good question. Nikki. Lori, there is so much rhetoric on this case. It's hard to keep up with it. I guess I was wondering if you think they have enough to convict him. Ann Taylor is really on top of this case. Oh, okay. I think Ann Taylor is a really good lawyer. And Ann Taylor has said something in court that defense attorneys don't always say. I've seen several of her hearings. She comes to court. She is impeccably prepared. She knows this case inside and out. She knows the case law inside and out. She knows the law. She is absolutely impeccably prepared for every hearing I've ever seen her in. But she says something in court that defense attorneys do not often say, which gives me pause. Defense attorneys are hesitant to say to a judge, I passionately believe in the innocence of my client. But Ann Taylor has said that on more than one occasion in public and before the court. I have no reason to believe that she isn't being completely honest and truthful about it. So What I can say is we don't know all the evidence. We haven't seen all the evidence. Really, what we know is what was in the probable cause affidavit. And remember, that is always the prosecution's theory of the case. We don't often get to see the defense theory of the case. And in most cases, most defendants keep their defense pretty close to the vest. Because they don't want the prosecution to be able to prepare for their defense. And so that's why Delphi is a little unusual, because we saw all of that came out in the Franks motion that challenged the probable cause affidavit. So we haven't seen all the evidence, but we have this defense attorney who is incredibly skilled and very experienced, who is putting her reputation on the line by standing up and saying, I passionately believe in the innocence of our client. That gives me pause. I don't know whether he's guilty or innocent. And my heart breaks for the families of those 4 beautiful young college students. At the time of this crime, my daughter wasn't so far out of college, and lived in a house very similar and was probably built by the same builder at the University of Oregon. So I have a hard time with it, but I also have a tremendous amount of respect for Ann Taylor, and think if she is willing to put her long reputation on the line for Bryan Kohberger, that says something. Because usually defense attorneys will zealously represent their clients. They will go to bat for them. They will file every possible motion. But it is unusual for a lawyer to stand up and say, I am passionately committed, and I believe with every fiber of my being of the innocence of my client. That's highly unusual. I think it's possible that he could get acquitted. If she feels that strongly about it, she must know something about the evidence that we don't know. And so I have to say, I think it's possible. I think it's possible that we're going to see a change of venue in the case. I know the prosecutor doesn't want that. And, I don't like the prosecutor. I don't like the idea that somebody might get away with these heinous acts and ending the lives of these lovely, promising young people. But I don't like the prosecutor, and I think he thinks he's got it buttoned down. So it's one that I'm surely going to be following very closely. And I highly recommend Andrea Burkhart, her channel. There is a link in our show notes to her channel as well. She's very familiar with the area and has been attending the hearings when they're not televised. So she'd be a great one to tune in on. So that's a hard one. Hey, Bo Peep, do you know if Dee Warner's preliminary will be televised? Also, thanks so much for your time. It's absolutely my pleasure to be here with you. I love being with all of you. Even when we disagree, I love being with all of you. And I think we have absolutely the best community. I think that we really, I'm proud of our community. I'm proud of our chat. And so I love spending time with all of you. Do I think Dee Warner's preliminary will be televised? I hope so. We have seen bits and pieces of recorded. We've seen him in court, and we've seen some news footage. so the court is allowing cameras in the courtroom, so that makes me suspect that it will likely be televised. And I hope that one of the networks, Court TV or Law and Crime, will pick it up. So I hope so. Michelle, or not Michelle, I'm sorry, Jen is waving at me, so I'm not quite sure what she's waving at. But I think it is time, if we don't have any more questions, it is time to say goodnight. So I want to thank everybody for being here. I want to thank everybody who has received the PDF of the book and, whoops, wrong side, been reading it. And I am going to do my best to do some members only kinds of get-togethers with the 100 or so who have gotten the early release of the book. And I am hoping that I'm going to see some great reviews coming up as we get closer to the release date. The book releases September 24th, which, according to my handy dandy countdown on my phone, is 33 days from now. Yikes. So I absolutely will be videoing the unboxing when my copies get here, and I hope that you'll join us for that. Don't forget, we are still doing a quilt, a paper pieced, a foundation pieced quilt of cranes, and we're still collecting those. So please, if you've made a square and want to make another one, please do. If you haven't and you would like to, please do. We have a new post office box. There it is, for you to send things to me. I do still have a handful of Justice for JJ and Tylee wristbands for anybody who might want to send me a self-addressed stamped envelope. So thanks again for joining us. Don't forget to download the pattern to the quilt or any of the other things that are in our show notes that might interest you. So with that, I am going to say goodnight. I'm going to thank Jen, as always, for her moderator par excellence. And I'm going to say goodnight. We'll see you next week.